Hello and welcome to this evening's Ethics and Professional Practice Common Law Exam Prep Bootcamp. My name is Sam Albanese, and I'm going to be your instructor for this particular session. As always, as we go through this, if you have any questions, whatever, I'll be happy to answer them as we go along. But remember always that you can always email us just simply go to your website and you'll see the email address there, and just simply send us whatever it is that you want, and we'll be happy to respond usually within 24 to 48 hours. Okay. So today we're going to be talking about ethics, and as I said, it's regarding common law. And as always, the purpose of all of this, of course, is to go over the must-knows, as they call them, need to know, whatever, clarify, obviously, any kind of concepts, misconception, whatever. And as we go along, like I said, we can always answer any questions, or by all means, email us. So let's get ourselves going now. Okay, the first thing we have to look at is the whole question of insurance contract. And in the industry, of course, we have two major divisions in there when it comes to insurance contract. There's insurance for life insurance, which of course is risk of dying, obviously, and the other more involved program, which is the accident sickness insurance. And that is, of course, risk of loss of health. So it's nothing to do with dying, but this is what we call living benefits, basically. So here we're going to cover disability insurance. We'll cover critical illness, accidental death, dismemberment, medical fees, drugs, things like that, and of course long-term care, and all parts in between. So those are sort of your two biggest areas when it comes to an insurance contract. Okay. So, but before we go there, one of the things we have to establish is how is it that insurance companies actually distribute products and everything. And the first thing we'll look at the sort of the left side of your screen there, you'll see there that in a more captive environment, you might say, there's an insurer, which of course is the insurance company, the manufacturer, if you want to call it. So the insurer really is the principal. And then there's what's called an agency relationship. So in other words, the insurer extends a contract to an agency, basically, or an agent if it's an individual. An agency usually is more than one person. An agent, of course, is an individual and everything. So the insurer has all the marbles, you might say, and then it basically extends that privilege, you might say, to agency or to an agent. Okay, so let's take a look at an agency first, because usually that's where most of you will be doing your business, through an agency, and then we'll be more specific about which agency we're talking about. An agency, generally speaking, is a partnership or a corporation. That's usually what is involved. Either two or more people get together, or it's a corporation, basically run a business. Okay. Regardless of which way you look at it, if it's a corporation, it has to have a corporate license. So partnerships don't have to have a license. Just the individuals, of course, have to have a license, but there's no partnership license. But there is a corporation license. So if you operate as a corporation, you must also not only have an individual license, in other words, a personal license, but also have the corporate license as well. Okay. All the employees dealing with the insurance company must also be licensed. In other words, anybody dealing directly with the insurance company has to have a license as well. You cannot give advice, you cannot talk about anything unless you obviously have that information and everything. Okay. Also, the agency basically deals with a number of different insurance companies, and of course, it allows, so the contract allows you to solicit for business, obviously obtain applications, transmit the insurance policies, collect premiums, develop illustrations, and so on and so forth. So there's lots and lots of rights that you actually get when you have an agency contract. But let's go back now to the captive side of it. Basically, in a captive environment, another name for it really is single company representation. In other words, you can only do business with one organization. So that is a direct relationship between the manufacturer, which we call an insurer, and of course the captive agent, which basically says you can only sell my product, and that's it. And that constitutes probably about 20% of the marketplace today. A much bigger chunk of the market, of course, is through the MGA. So the managing general agent basically deals with a number of different insurance companies that can deal with 2, 5, 10, 15, depending on how big they are and everything else. Many of them are quite large. So they can deal with many insurance companies and everything. And so those insurance companies basically give contracts to the managing general agency, and that managing general agency then extends contracts to the independent agent. And so therefore, you as an independent will simply go to the MGA, say, I want to do business with XYZ company, whatever, and they have it, and they'll extend the contract for you. So in the process of doing that, of course, the MGA provides a tremendous amount of support for you. So it will help you, agents, obtain contract with various different insurance companies. You process and track all of your business, provide sales support, collects and pays commissions. So again, you don't have to worry about conflict of interest because the commissions are going to be the same regardless of the insurance company. So you don't have to worry about which one pays better, so to speak, because it's sort of a universal number, you might say. And of course, provides an enormous amount of training to you as an independent agent. So as you can see, that the MGA is a crucial person in your development and everything. So today, probably about 60 to 70% of all business written in Canada is through an MGA system and everything, And so those are your two major distribution. Of course, there's some minor ones, so online, for example, or through the internet, things of that nature there. But these are your two major distribution centers, you might say, through a captive environment and through the MGA independent channel environment. So let's move on. And in order for an individual, of course, to enter into an agreement to sell life insurance or get a contract or whatever it is, two things must happen. The first one is there has to be what's called the age of majority. So depending on the province that you happen to be in, it's either 18 or 19. Okay, so Ontario, for example, is 18, whereas many of the eastern provinces, like Nova Scotia, for example, it's 19. So the very first thing, in order to be able to actually enter into any kind of an agreement, you have to be an age majority. The second part of that equation, of course, is legal capacity. And that basically means that you're not impaired in any way. In other words, you're not under the influence of drugs, alcohol, or anything along that may sort of cloud your mind. And therefore, you're not making a clear decision, objective decision. So you must be a legal capacity in order, basically, So in any case, legal capacity, again, is something that you really have to take a look at very carefully to make sure that you are in a position where you can enter into an agreement and everything. So let's move on to the next slide, and we look at minors. As we know, one of the questions usually on the exam is, can minors basically be beneficiaries, for example, in an insurance contract? The answer is yes, a minor can be the beneficiary. The question is, can a minor receive any monies? And the answer is no. Okay, in order to actually get money, you have to be of the age of majority. Like I said earlier, it has to be either 18 or 19, depending on your province. So there's the provinces there, because the age of majority for 18 years old, Alberta, Manitoba, Ontario, PEI, basically, my apologies there, Quebec and Saskatchewan. Age of majority for 19-year-olds are, of course, the BC, New Brunswick, Newfoundland, Labrador, Nova Scotia, Northwest Territories, and Nunavut and Yukon. Okay, now a person 16 years of age or older has the capacity to contract for insurance for themselves. They cannot buy insurance on somebody else, but they can certainly buy insurance on themselves. And the reason for that, of course, is the legal age for marriage in Canada is 16. So therefore, theoretically, you could buy life insurance on yourself at that point. Okay. Other people that have rights, of course, to buy life insurance, of course, are your parents. Parents can buy insurance on minors. In fact, parents can buy insurance, and anybody, quite honestly, any of the children, as long as the adult children give consent. But if it's a minor, of course, then the child has no right to give consent. But the parent certainly has a right to insure the child, again within reason, obviously. Okay, and of course, the other person that has the right to insure is a court-appointed guardian. So any guardian for the children and everything, they also can buy insurance on those minor children and everything, because they have, again, the legal capacity and everything. So let's move on. This is a very important section, the power of attorney. So in the power of attorney situation, what you've got essentially is two powers of attorney, two different kinds of powers of attorney. One of them is what we call the power of attorney for personal care. Another name for it is living wills. So basically, this is a power of attorney that you're giving to somebody should you get to a point where you are, regarding your health, in a position where you can no longer make right decisions for yourself regarding your health. So what you would do, obviously, is you would give that power to somebody else. Okay, so you as the grantor, as they call it, are granting authority to an attorney, in other words, somebody else, so that if should you become incapacitated and somebody has to make decisions on your behalf in regards to your health and everything else, a power of attorney for personal care is the right document. That's why they always call it a living will. In our business, we don't tend to do the living will section as much as the power of attorney primarily for your wealth. In other words, power of attorney for property. In that case, there you have basically two kinds of power of attorneys. The first one basically is what they call a limited power of attorney. That's what we're talking about here. The power of attorney ends when the person who gave the POA becomes mentally incapable. So this is very much of a limited power of attorney. So, for example, if I said to you, I'm going to go away for the next 12 months, would you take care of my house? Rent it out for me, go in there in wintertime, make sure the pipes don't burst, basically take care of my property. However, after the 12 months, I'm going to be back, so therefore it is a limited power of attorney. Or if I become mentally incapable, that limited power of attorney is also finished. Okay, it's finished. Okay, generally speaking, for our business, we go to the next step. We go to what's called an enduring power of attorney, and this is the one that always shows up on the exam, is an enduring power of attorney. So basically, the difference is that an enduring power of attorney continues even if the person who gave the power of attorney becomes mentally incapable. So in a limited power of attorney, it automatically ends when the person becomes mentally incapable. In an enduring power of attorney, it goes past that. So basically, the moment the person becomes mentally incapable, they can actually then grant you the power, you step in, and now you have the right to turn around and actually act on their behalf. Now remember, this is not something that you take lightly. This is a very responsible position, because at the end of the day, you have to do the best you can in regards to the grantor, the person who gave you the power, and of course to the beneficiaries of the power of attorney, whoever they may be as well. Okay, so this is an important section. Two things that a power of attorney cannot do. So for exam purposes, you must know this, that two things that they cannot do for power of attorney. They cannot do, that is, they cannot change the beneficiary of an insurance policy on the grantor, obviously for obvious reasons, because if they could, they'd obviously make payments to themselves, so that's obviously clearly a conflict of interest. And the second thing they cannot do is they cannot make a will on behalf of the grantor as well. Once again, the reason is obvious. If you can make a will on behalf of the grantor, then what will end up happening is that you're going to make yourself as the sole beneficiary of the estate, and that's obviously a conflict of interest as well. So two things that cannot be done in regards to power of attorney for property is change the will and, of course, change the beneficiary. In both cases, could be construed as a conflict of interest. The other person that has power is the guardianship. In other words, if you have minors and you leave the children in the guard of guardians, to a certain relative of the family, or maybe a court-appointed guardian or whatever, they also have power, of course, to act on behalf of that child, or I shouldn't always say child, because it can also be an adult. If that adult is mentally or physically disabled, the guardian again can make decisions on their behalf. Okay, so this is a very important section of the Act and everything else, and strongly recommend that you read the section in the book that talks about this, because you will definitely get a question on the exam in this particular area. The other section, of course, we have to look at is the whole question of marriage and common law spouses. First of all, marriage is a federal act. As it says, the marriage is a legal status, and is really governed by the federal laws. Even though the actual celebration itself happens from the provincial law, in other words, the province really sort of, you might say, administers the act, but from a legal perspective, it is a federal act. Okay, and so therefore, as a marriage, we usually recommend a prenuptial agreement, marriage contract or domestic contract, something to the effect that should there be a breakdown, a divorce, in other words, property will be appropriated accordingly. As you can well imagine, divorces can be very, very messy. So if you have a prenup, it really, really helps because at the end of the day, the prenup will be put in court. Basically, it's okay. This is what we agreed to way, way, way back when we first started our relationship and everything, and so therefore, this is how the property will be appropriated accordingly to that agreement. So, for example, inheritances, gifts, things of that nature. They could all go into a prenuptial and say the inheritance, the gift, and all that will not be part of the matrimonial property and everything. So, basically, like I said, marriage is serious business. And what happens if in a marital breakdown? Of course, will be subject to property division, and the property division will be very much according to the province that you happen to be in there. So that's why we always say advise clients to seek competent legal advice. This is very serious stuff. Common law relationship. This is all over the map. Depending on where you are, which province, because the common law is not a federal matter. Okay, it is a provincial matter in terms of a marital breakdown. In terms of family property, it falls under the provincial matters, not the federal matters. The government of Canada, the federal government, basically says that you are married if you're living in a conjugal relationship for 1 year. With that person, with that spouse, basically, for 1 year, then for income tax purposes, you are considered married. And that's the only time the federal law says anything at all about the common law relationship, in that it is a relationship that in a conjugal relationship for 1 year, then you are considered basically married for income tax purposes. Other than that, it's the provinces who dictate what the definition of common law. So, for example, in Ontario, common law relationship is 3 years. In other words, conjugal relationship with three or more years, maybe 3 years minimum. Or again, if you have children, within that 3 years, obviously it's a conjugal relationship. In which case, that you would be married as far as the province is concerned, and therefore then subject to provincial rules in terms of breaking the family property and things of that nature. Okay, so in a common law, because it's not really a marriage, but it's really more, you might say, a relationship more than anything else, then we don't call it a prenuptial, but we call it a domestic contract or cohabitation agreement. Once again, very similar to a prenuptial in that it very clearly outlines that in the event that we separate for whatever reason, this is what's going to happen to the property. It's how we're going to split up the properties and so on and so forth. So once again, it's a good idea to have that, because some provinces, in terms of a marital, sort of a common law breakdown or separation, are not necessarily subject to property division. You have to look at the individual province that you happen to be in. So, for example, in Quebec, there is no common law. So, in other words, common law simply is not recognized, and that's the end of that. So, without a properly drawn up agreement and everything else, certainly one of the parties will be disadvantaged and everything. Okay, but regardless of which way you go, whether you're in a marriage or whether you're in a common law relationship, the rights to spousal support and dependent support, in other words, child support, is still there. And most important, of course, is the child support. That is a federal matter. Spousal support is more of a provincial matter, although the federal government gives guidelines basically as to spousal support in the event of a breakdown or a separation or anything along that line. So it is a very important section of the Act that you know the difference between a marriage and a common law relationship and everything. So let's go on to a divorce itself. As I said, just like the marriage is a federal act, so is divorce. Okay, so divorce, again, is a federal matter, and so therefore it falls under the federal jurisdiction. However, in terms of breaking up the property, in other words, family property, it does go according to family law of the province. So while the federal government is involved with divorce, it is not necessarily get involved in how to break up the division of property, the family property or something. So as long as you are separated, okay, obviously you cannot get married. Okay, so in other words, you must get a divorce before you actually get married. So one of the things that divorce gives you is the ability, of course, to remarry. But again, with that, spousal support could be an issue. And that, again, federal government will give guidelines in terms of the kind of spousal support that would be needed. Okay, and of course, child support. Okay, child support supersedes spousal support. In other words, child support is first, and that's a good thing. Children should always come first, basically, and then in terms of the federal law, the child support is law. So unlike spousal support, which are simply recommendations at this point, anyways, they're recommendations. Child support is not recommendation; it is law. And so, therefore, if you earn X amount of dollars and you have Y amount of children, this is how much you must pay for support. So there's really no discussion because it's already dictated by the Divorce Act. Okay, the provincial jurisdiction, on the other hand, they're more concerned about financial status and, of course, division of property. In other words, more like spousal support, child support, basically dictated by the feds, and of course, how to actually divide the property among the couples, basically. Okay, so many times what happens, life insurance policy could be subject to valuation and division. For example, if you buy a universal life policy and you have a very high cash value sitting in that policy, or whole life policy participating, let's say, which again has a very high cash value, the court should say half of that money will have to be sent over to the spouse. Based, in other words, life insurance itself, the cash value, not the death benefit, obviously, but the actual cash that's in the policy could be subject to marital property division and everything else. Okay, the insurance proceeds received will be treated analogous to inheritance and gifts. In other words, inheritance and gifts are not considered family property. So life insurance proceeds, the death benefit, okay, will not be considered as family property. It will be considered an inheritance or a gift, basically. And so therefore, it will not be subject. However, the cash value in the policy while the client is alive, the cash value, that will be, could be subject to valuations, family property. But the death benefit, it definitely is not. Okay. So let's move forward and get on to the next big section, of course, is trust and trustees. Trusts are very, very useful tools because from a tax planning perspective and privacy perspective, things of that nature there, as you know, a will is a public document. A trust is, of course, a private document. And so therefore, you can privately set properties aside, put it into a trust, and quite honestly, nobody needs to know. Because it doesn't really form part of your estate. Once you move property from yourself to the trust, now the trust owns the property. And therefore, because the trust owns the property, it doesn't form part of your estate. So, of course, you avoid probate, you avoid creditors, you avoid all that kind of stuff there. And, of course, the spying eyes of, maybe a disgruntled heir or something, So once property is moved over, the trustee now hold title to the property. So the trustee technically owned the property on behalf of the beneficiaries. Okay, of the beneficiaries. So they don't hold property for themselves. Obviously, they hold property on behalf of the beneficiaries. And therefore, it's a big responsibility. You cannot take these things lightly, okay? We usually also recommend that you have a surrogate ownership of the trust. In other words, don't just have one trustee, because if that trustee happens to be away, cannot, or maybe disabled themselves or sick, or maybe even the trustee might have even died and you haven't even had a chance to claim when you move trustee. We usually recommend that you have a secondary trustee just in case, just like, you have a secondary beneficiary, contingent beneficiary. We recommend the same thing. Have a secondary trustee as well, just in case, basically. But the role is the same, okay, is that once property moves over to a trust, it is property of the trust. And the trustees now have legal title to it, you might say, on behalf of the beneficiaries, okay? There are two kinds of trust. There's inter vivos trust. These are trusts that you set up while you're actually alive. So you as the settlor, basically what we call you the settlor, you settle the trust. So you open up the trust while you're still alive, and you seed it. In other words, you throw in property. That property could be money, it could be a cottage, it could be a house, could whatever it is. You cannot set up an inter vivos trust without settling it with something, even if you have just put in $100, let's say. But there must be something to essentially seed it. And that is very useful, like I said, for privacy purposes, for tax purposes, estate purposes, so that you leave property to somebody that you may that you want to make sure that they actually get that property, but you're still alive. That's why they say inter vivos. So you're doing this while you're actually alive. In the property, you, the settlor, settle this while you're actually still alive. Okay. Testamentary trust, on the other hand, is a trust that's set up through your will. So therefore, this particular trust comes into effect the day you die. So unlike an inter vivos trust, which is settled while you're alive, a testamentary trust actually gets settled the moment you die. And so in a testamentary trust, very similar to any other trust, has a trustee basically named and everything. And once again, the testamentary trust owns that property at that point on behalf of the beneficiaries. So once again, the trustees hold legal title to the property on behalf of the beneficiaries of the trust, and therefore manage property accordingly, and go according to whatever it is that you decided. So trust can be very, very useful, like I said, for privacy issues, state issues, probate, creditors, all that, because basically trusts are private documents. Unlike a will, which is a public document, a trust is a private document. So very, very useful tools for various different purposes and everything. Let's go on to the next one, which of course is bankruptcy. So when we're looking at bankruptcy, basically, if you're going to go bankrupt, what happens is the courts will appoint what's called a bankruptcy trustee. Basically, the bankruptcy trustee now takes a hold of your estate, basically takes a hold of your affairs and everything else, and handles all that on your behalf. So it basically controls properties and assets and everything else that may be in your estate and everything, and it will deal with creditors on your behalf. So it could cut deals, 30 cents on every dollar, for example. There's all kinds of different things they can do. What they try to do is act very much like a mediator, so they can deal with various different creditors, take whatever properties and assets that are available, liquidate them if necessary, to satisfy the creditor's needs, and basically make them all go away, you might say, on your behalf and everything. So essentially, if you've gone bankrupt, basically that's what happens, is a trustee actually gets appointed, and that trustee then acts on your behalf for the creditors and everything. Okay. Now there are some properties that are protected against seizure. So if you look at the left hand of the slide, basically, you'll see they're protected from bankruptcy or seizure. And that is for life insurance, annuities, secluded fund policies, which beneficiaries are preferred class. And this is very, very important. If you name your estate as the beneficiary, let's say, of life insurance or your annuities, or you name somebody that is outside of the preferred class. Remember that the preferred class was your mother, your father, your spouse, your children, your grandchildren, and any legally adopted children. Those are your preferred beneficiaries. Okay? So leaving money to any of those people there are basically the creditors cannot attack that money. Leaving money to your brother, your sister, your uncle, your aunt, things like that, they are not part of the preferred class. They are what they call the other class, you might say, not preferred class, and they will be subject to creditors. So if you leave money to your brother, for example, life insurance policy to your brother, and you go bankrupt, and the estate owes a lot of money to creditors, the creditors could in fact go after your brother's life insurance policy that you left them, whereas they couldn't do that if you left it to your spouse or your children or something, because they are protected, whereas brothers, sisters, uncles, aunts, and all that, they're not protected. Your company, for example, is not protected. Your partner is not protected. It's in partnership insurance, things of that nature there, okay? So if you want to make them protected, then you have to go one step further. That is, you can name them irrevocable beneficiary. So one good reason to have irrevocable beneficiary is that you can protect it against creditors. And that's the idea of irrevocable, one of the ideas anyways, in regards to irrevocable beneficiary, is that you can protect your brother against creditors, seizure and everything else, by naming your brother as an irrevocable beneficiary. But again, a cautionary note in that, as you know, there are a lot of restrictions when you name somebody irrevocable. The big one, of course, being that you can't change the beneficiary without their consent and everything, right? So we got to be careful before you jump in and say, okay, well, I want to protect that money against someone and name somebody irrevocable. Remember the ramifications here is that you may never be able to get that policy back, essentially, So moral of the story basically is to protect your money. You can leave it basically to the preferred class or irrevocable beneficiary, and those are your two best ways to do it. I should mention, by the way, that when it comes to putting money into RSP, for example, any amounts of money that you put into the RSP in the last 12 months, since you become bankrupt, let's say, in the last 12 months. So let's say you became bankrupt today. Monies that you put into your RSP in the last 12 months, creditors can actually seize that money. So the last 12 months, you'll see that 12 months comes in quite often in that if you transfer any funds at all from your estate to any other vehicle in the last 12 months of going bankrupt, the creditors could, in fact, roll that money back. So any RSP money that you might have put in other words, your RSP deposits for the year, and then you went bankrupt, the creditors could, in fact, come back and take those funds back. Okay? All right. So in order for a contract to be valid, in other words, as you know, that's what we sell. We sell a contract. And so the first thing we have to look at is that there must be intention to enter into a binding contract from both parties. In other words, both the life insured or insured, whatever, and the insurance company say, yeah, this is a good idea. Let's do this. In other words, neither one of them can be subject to any deceit, any coercion, any threats, anything along that line. So both of them had intention to actually enter into the agreement because it made good sense, it made good business sense for the two parties to get together. Okay. The other thing that must happen is the subject matter of the contract has to be legal. In other words, if the contract was, I want you to blow up this building, well, that's not a legal contract because now I'm asking you to do something illegal. In other words, if the contract is to do an illegal act or an illicit act, basically, then of course we have no contract because of course it goes against public policy. In other words, if I contracted you to murder my spouse, for example, obviously, or rob the bank or blow up the building or whatever, those of course are illegal matters, and therefore that contract will be null and void right from the beginning, basically. Okay. Also, both parties that enter into a contract must have mental capacity. In other words, they cannot be in a situation whereby one maybe have mental issues or something, or under the influence of drugs or alcohol or anything along that line. You really, really have to enter into an agreement with very much of a clear mind that you know exactly what you're doing. There was no question that you knew what you were doing, and you decided to continue on, basically. So it is a very important part of the agreement. Okay, and as I said before, both parties have to agree that this just makes good sense for us to enter. In other words, the offer and acceptance have to be consistent. That in both parties, the offerer and the offeree basically are saying, yeah, this makes good sense. Let's proceed on that. Otherwise, we do not have a contract. It's really as simple as that. Okay. Now, there are, of course, many insurance company products and everything else. What we call public insurance. In other words, just simply the fact that you're living in Canada, you have rights to the insurance. And there's also many plans, of course, that provide you with retirement money. Again, just living in Canada. In other words, you don't really have to do anything. It's just simply the fact that you're a resident of Canada automatically basically gives you those rights. Okay, so the first one is, and most of you should be familiar with this, is what we call the federal programs. And this, of course, is CPP, kind of the pension plan. old age security, and GIS and EI. Okay, so CPP, OAS, GIS, EI. Another one is allowance, which should be under federal there. Basically, these plans are all federal plans. So if you've been contributing to CPP since you were 18 years old, let's say, or you've been living in Canada since you were 18 years old and working obviously in Canada and everything, then you qualify for CPP. You old age security, whether you work or not, as long as you're a resident of Canada. When you're 65, of course, you'll get a pension. EI, of course, basically means that you have been working in Canada and you have credits and everything. So all of those are federal plans. But the provinces also have many plans. And the provinces, of course, have what's called no-fault automobile insurance. Not all provinces have, but pretty well most of the provinces in Canada have no-fault automobile insurance. In other words, if I smashed your car, basically your insurance company will fix your car, my insurance company will fix my car. In other words, it was nobody's fault. The respective insurance companies fix the insurance car, and as simple as that. Okay. Workers' compensation, of course, is for work-related injuries. So any companies that have workers' compensation, you are injured on the job, you're covered on that. And of course, all provinces right across Canada have the universal health care and some kind of a drug plan of some kind as well. So both the federal government and provincial government do have programs that will assist you so that you're not left sort of penniless, you might say, in case a tragedy should strike and everything. Of course, you and I are in the business of private programs, okay, and that is why you're trying to get your license, because at private programs, you sell life insurance, we sell pension plans, we sell car insurance, we sell homeowners insurance, we sell all those kind of things there. So these are basically programs that are coordinated between the private and the public plans. So basically, the coordination of benefits is between the federal government, provincial government, and of course the private programs. They're all sort of get together, and we look at the needs, like a needs analysis and everything, and then the appropriate division, the appropriate government or private plan pays accordingly. Basically, so there is a great deal of harmonizing between public plans and private plans, which of course is the plus that you sell, basically. Okay, so let's take a look at some of these a little more in depth. The first one is CPP, and as I said before, it is a contributory plan. And so the end result is that from age 18 onwards, and if you are working in Canada, you must contribute. So in other words, it is a mandatory contribution. You can't say, no, I don't want to participate. You must participate. And this is both the employer and the employee participate in in this program. Self-employed person, of course, contributes both. Okay, so if you're a sole proprietor or self-employed, basically you contribute both the employer and employee portion. So in terms of the contribution amounts, the employee covers 4.95% of the earnings between the YBE yearly basic exemption, which is $3,500, and the YMPE, which is your maximum pensionable earnings. Okay, so the YBE yearly basic exemption is $3,500. In other words, up to $3,500, you do not have to contribute anything. Once you're over 3,500, you need to start to contribute. But there is a threshold, and that threshold is the YMPE, yearly maximum pensionable earnings. So, for example, for 2016, it was around $53,000 or something. So basically, it's 3,500 minus $53,000 and times 4.95%, and there you go. Okay, the employer also contributes 4.95% of the same thing. So whatever you see on your paycheck, your employer has contributed the exact same number, because it's basically 9.9 split right down the middle. So as a self-employed person, you will be paying 9.9% of the difference between the YBE and the YMPE. And as I said, the YMBE unit basic exemption is around $3,500. Is $3,500 per year. The YMPE is $54,900 for 2016. I believe for 2017, it's a little bit over $55,000. Okay, so the YMPE is indexed basically. The normal retirement age is 65. Okay, that's the normal retirement age. However, if you want to retire earlier, you certainly can do that, but you cannot retire earlier than age 60. So in other words, your CPP the earliest it can start is age 60 onwards, basically. And for each for each month that you retire early, you must reduce it by 0.6% per month. Okay, so for every single month that you retire early, you lose for 0.6%. So if you extrapolate that, you'll see that roughly around 36% will be your losses if you start at age 60. Okay, on the other side, of course, if you retire later, up to age 70, in other words, 60 to 70 is what you got. If you were 65, you decide you don't need the money, you like to keep it for a little longer. You go up to age 70, and you put in 0.7% for each month that you delay. Okay, so again, if you extrapolate that to age 70, you get a nice 42% more than what you would have got at age 65. So for those of you who don't need the money at age 65, you may want to continue on letting it grow at a rate of 0.7% per month for a total of 42% over the 5-year period of time. Okay, so if you were to retire, now, for example, in 2016, let's say, because that's what these numbers are, is 2016 numbers, you would get $1,092.50 per month at age 65. Okay, now remember that regardless of how you look at it, the benefit is the receipt is taxable, because remember you deducted your premium, and so therefore the benefit itself will be taxable as well. So that's your CPP. The next one, of course, is old age security. Now, the good news about old age security is you don't have to contribute anything. All you really have to do is be in Canada, basically. In other words, be a resident of Canada in order to qualify for this. Okay, so this non-contributor. So even if you never worked a day out of the house, you might say, never worked a day out of the house. So you still will get the money at age 65, provided certain conditions. In other words, the residency is what it means. It's the main thing here. So the qualification is 65 years or older. In other words, you can't get OAS any younger than 65. So it'd be 65, or you could delay it if you want. Okay, you must have a minimum residency of 10 years after age 18. It doesn't have to be consecutive, but you must have at least 10 years in order to get any kind of a pension. And to get the full pension, of course, you have to be 40 years in Canada. Basically. So basically what we're saying is that basically 10 to 40 years, that 40 years being your maximum. Okay. Now, again, using 2016 numbers, the full pension would have been $570.52 per month. So if you, again, extrapolate that, it's roughly about $7,000 a year. But if you decide, just like your CPP, you don't need the OAS, the monthly payment could be increased again by 0.6%. Per month, in other words, 7.2% per year to age 70, basically. So in other words, you get an extra 36% by deferring it for 5 years, basically. So if you don't need the money, just like you did with CPP, you can simply delay it, and for every month you delay it, you're going to get 0.6% more. So it'll be strictly up to you. Okay. There is, however, one big issue with old age security that doesn't apply to CPP, and that is that you have a threshold. Okay, so for 2016, the threshold was $72,809. So, in other words, you're allowed to earn up to $72,809, and there will be no clawback. Okay, there'll be no clawback. But the moment you're over $72,000, for every dollar that you earn above the $72,809 for 2016, you will be deducted. You will lose 15%. Okay, you lose 15%. So for every dollar above the threshold, you in fact will lose 15%. So if you extrapolate that, roughly about $119,000, you will lose the OAS completely. Basically, so you need to factor that in when you're doing your planning and everything. In that there is a clawback. One of the drawbacks to OAS is that there is a clawback. Anything above the threshold is 15%. Okay. Once you are on old age security and you are in a very low income bracket, usually less than $25,000. Okay, you can also qualify for GIS. Okay, so basically, so if your spouse is not receiving OAS, you could get GIS on top of that. And if your spouse is receiving OAS, you get a little bit less, like say $512. In other words, the GIS, first of all, you need to be 65 in order to get OAS, and you need to be 65 or older to get GIS as well. And of course, you're very low income. If you have a spouse that is younger than 65, but is age 60 or older, okay, from age 60 to 64, and again, you're in a very low bracket, low tax bracket and everything, low income earner, basically, your spouse, who is that 60-year-old spouse, age 60 to 64, will also get an allowance. But remember, you must be 65 or older in order for the allowance to kick in. So in other words, if you're not getting OAS, then you can't get GIS, and your spouse can't get an allowance. So you must be getting OAS first. So that's your first qualifier. Then from there, if you're a low income earner, you'll get GIS. And if your spouse is a low income earner between age 60 to 64, they will get what's called an allowance. Okay. Should you be receiving OAS, in other words, you're over 65 and getting OAS, and then you pass away, your survivor will get $1,213 per month until they're age 65, and then at age 65, of course, the normal OAS kicks in, anyways, and so that simply dies off, and that's it. Okay, so that's basically all you need to know really for old age security. Okay. EI, employment insurance, again, mandatory. If you work at age 18 onwards, you must pay EI. So employer and employee are the people that are the two parties, obviously, and they will pay a percentage from up to the maximum insurable earnings. You don't have to remember these numbers. It's not just for illustrative purposes. That's all really. There is a minimum number of insurable hours. So depending on the province and all that, wherever you are. So for example, anywhere between 500 to 600 hours on a rolling 12 is usually a number. Basically, that you need employment hours on a rolling 12 to actually qualify for EI. The actual benefit is 55% of insurable earnings to a maximum of $537. Now, again, that changes because sometimes what happens is, the plan itself increases every year. It does increase according to consumer price index and everything. So the end result is that if you're in a position basically whereby year by year you are unemployed, you might find yourself in a position where you're actually getting a bit more year by year essentially. But basically, the plan is a 55% of insurable earnings to a maximum of, and that number changes all the times. The key thing to remember about this here is that it is reduced. Okay, it is reduced by any other earnings. In other words, EI is a second payer. So if you're already earning well over $537 a week in our example here, you're not going to get any EI because you're already getting over the maximum anyways. You see, so it is integrated. If you're getting less, then EI will make up the difference, you might say. But if you're getting more than $537 earnings, either through earnings, commissions, or workers' compensation, or CPP, anything at all, basically, EI is automatically a second payer. But if you're getting less, then EI will in fact make up the difference. Once again, because you've taken a deduction in this, EI is a taxable benefit. Okay, so in other words, this will be considered earned income, and basically then it will be taxable income. So you do have to report that on your T1 every year and everything. Okay, so Most provinces today do also have no-fault insurance, okay? And basically, what it means, as I said earlier, is that each insured person looks for benefits from his or her own insurance company. In other words, you don't sue the other insurance company. You just basically phone up your company and say, "I've had a problem," and then they basically pay for it, and that's it. Essentially, so you don't actually go after each other. So each insurer basically pays the client whatever they need to be paid for. Okay, that's why they say it's no fault. Okay, now fault will be determined by the insurers based on the various different determinants. Basically, some provinces they will look at what they call fault will be determined by the insurance based on the fault determination regulations, and that's what I'm saying. Depending on the province, and not necessarily everything is no fault. Car insurance certainly is no fault. But sometimes home insurance may not be in that position at all. Okay, so you certainly have to look at the various different provinces, see what they mean by no fault in your respective province and all that. Okay, so as it says, in some provinces such as BC, Saskatchewan, Manitoba, QC, they have their own government-run insurance programs, and the private insurance simply top it up. In other words, the provinces will cover you up to a certain point, and then the private insurance company. You can top it up. In other words, you want extra coverage and everything else, you can go to the private insurance company to do that as well. Okay. Workers' compensation. Some of you are quite familiar with this, I'm sure. Okay, workers' compensation is basically covers you while you are at work. And so here the contributions are employer pay all. You as the employee do not pay anything. So all the other plans we talked about, CPP, EI, things of that nature there, all of that is all employer-employee, that kind of stuff there. Workers' comp is employer pays everything. And basically it covers you for accidents or illness while you are on the job. So while you're going home or coming to work or on holidays, on weekends, whatever it is, you're not covered. So this is basically not 24/7 coverage like the other plans are. This is really 8-hour coverage while you're actually at work. Okay. So the benefits themselves, they pay you for loss of income, prescription drugs, medical treatment, medical equipment, rehab, loss of future income, loss of quality of life, death benefit. Now, there's no actual numbers here because it all depends on the adjudication process. In other words, all of these claims will be adjudicated by workers' comp, and then they will decide what you're actually entitled to. So a rule of thumb in regards to income is that they will usually cover up to 90% of your net income. In other words, the idea is to give you about the same amount of money that you were already earning, taken home basically before you became disabled. Okay, that's just again a rule of thumb. But like I said, all these things are adjudicated, so you really do have to take a look at very carefully as to what's covered and what's not covered. The good news about workers' comp is that it's all tax free. In other words, all the other stuff you have to report. In this case here, there's no reporting done. So basically, employer pays everything. You're covered, and you never have to. Whatever monies you get, and you never have to report that as income. But just again, bear in mind, there's no spousal benefit here. There's no children's benefit. Whereas, like with CPP, there were spousal benefits. There was children's benefits. Things of that nature. There, here is strictly coverage for you as the employee, only while you're actually working and at work, and that's it. So most provinces today have some form of universal health care and drug plan. So basically, the plan sponsor is the province. So even though the federal government, through the Health Act, you might say distributes monies and everything else to the various provinces, but the provinces actually administer the Health Act. Okay, so it is a provincially driven administration process, and the healthcare itself is universal. In other words, it's pretty well consistent from province by province. Basically, it's pretty well consistent. That's not a problem. However, the drug plan is a little bit different. It's not necessarily universal. Some provinces have that it covers all your drugs and all that sort of stuff as well. Some provinces, no, we don't cover drugs outside of the hospital. Those you have to pay yourself and so on. Okay, so you do need to take a look at your respective province to see what drug plans are available. Many of them will have, special programs for low-income earners, for disabled people, for seniors. So there's all kinds of ways and means that if you don't have the means or the resources and everything else, that you can still get drugs at a reasonable cost and still and still be covered and everything. But once again, you have to take a look at your respective province to see exactly what is it that they cover. Okay. Let's look at the legislation now in terms of you as the agent, okay? Things that you need to know in terms of taking care of your affairs and things you should and should not do. The first one, of course, is very, very important, the Privacy Act, which is a federal government. That is, of course, PIPEDA. You most definitely will get a question on this. And then basically PIPEDA is designed to protect the identity, the privacy of the individuals. So any organization in Canada, any company, corporation, whatever, that takes information on behalf of the clients and everything must keep the information private under lock and key. Must be backed up by computer systems, and in other words, the safety features, because this is private and confidential information, and information should be used for only for what it was intended, not for public consumption or anything along that line. Also in Canada, of course, we have the Human Rights Code, so there'll be no discrimination based on gender, religion, skin color, nationality, family status, marital status, sexual orientation, your age, all those kind of things there. Those are all things that we hold dear as Canadians, okay? And these, of course, fall under what's called the Canadian Human Rights Act, which is a very, very important document and well respected throughout the world, basically. So insurers, however, are permitted to discriminate in providing insurance coverage as long as they can justify it on a reasonable basis. In other words, the insurance company is not obligated to insure absolutely everybody. In other words, it could be a situation where the individual is in such bad health that there's just no way that we can afford to insure this person. So therefore, we will decline him, or we will put in exclusions or limitations or anything along that line. And so basically, the insurance company does reserve the right to say, look, this is a very, very bad risk and will be a detriment to the success of our company and everything else, which could lead to failure, which of course could lead to all sorts of other ramifications. And so therefore we do reserve the right to decline people who we feel simply do not fit our model, our regulations, health issues, income issues, and so on and so forth. Okay. And so it's not necessarily a question of discrimination as much as a question of protection against bad risks, basically more than anything else. Okay. There are some things to fall under, of course, the criminal code. And again, I strongly suggest that you read this very carefully because you will get a question on the exam on this. That is, of course, the proceeds of crime, money laundering, terrorist financing activities. Okay. As you know, if you suspect anybody that may be involved in terrorist financing or money laundering, you must report that to FinTrack within 30 days of having this information. Okay. The other two, do not call list. Of course, if somebody calls you and your name is on the do not call list, and they go ahead and they call you anyways, you can actually sue them or you can report them, and they, of course, will be reprimanded accordingly. And the next one, of course, is the anti-spam legislation, which came into effect about 2.5 years ago now. Which again is to avoid getting emails, unsolicited emails from somebody trying to sell you something. Basically, you do have the right to unsubscribe, so to speak. And once again, if you are getting those, even though you have unsubscribed, you're still getting them. Once again, you can report them, and they will be severely reprimanded by the law and everything else. Okay, so these are things that fall under the criminal code, basically. So let's take a look now at the various different insurers, basically the individual policies. What constitutes an insurance contract? Okay. Well, the very first thing, of course, is the insurer, which is, of course, the insurance company. Okay, you have to have a manufacturer, so an insurance company. Then the insured, which is, of course, the policyholder. Sometimes they call it contract holder, sometimes policyholder, sometimes the insured. Basically, the insured has all the contractual rights. In other words, all the power lies with the insured. They are the ones that can make changes. They can cancel policy. They can increase, decrease, stop payments, all kinds of things, based cash in the policy. In other words, the insured has all the power. The life insured, of course, is the body that we're insuring. Okay, the life insurance is the body that we're actually insured. So the life insured, from a legal perspective, really doesn't have any rights at all. All the rights lie with the insured. So as it says there, it's personal insurance if number 2 and number 3 are the same. In other words, if I buy a policy on myself, I am both the insured and the life insured. And so therefore, I do what we call a personal insurance. But if number 2 and number 3 are different persons, then it was called a third party or tri-party contract. In other words, if I buy a policy on my wife, or I buy a policy on my child, or I buy a policy on my partner, that is a third party contract. And so I am the insured. In other words, I still have all the rights. And my spouse now is the life insured. But like I said, the life insured doesn't have any rights. All the rights lie with the insured. Okay, and that's why we always recommend in a third-party contract that you have a successor policyholder. Okay, should the policyholder predecease the life insured? In other words, if I own a policy on my spouse and I end up dying, who owns the policy? Well, if I don't have a successor owner, then my estate will own it. See, so if my estate automatically steps in and owns anything that I own, unless I specify otherwise. And that's why we always recommend that if it's a third-party policy, that you have a successor policyholder, so that I die, let's say, and I leave my spouse as the successor policyholder. She automatically steps into my shoes, and life goes on from there. Otherwise, it will go to my estate, which will then be subject to probate and all sorts of other nasty things that can happen. And so we strongly recommend that in a third-party policy, you always have a successor policyholder or contingent policyholder, if you want to call it that. Okay. Let's take a look now at beneficiaries. Now, we alluded to these beneficiaries before. And as I said, there's 2 big groups of beneficiaries. The first one, of course, is the most favored, which is what we call the preferred beneficiaries. Okay, preferred beneficiaries. Preferred beneficiaries basically is the spouse, the child, the grandchild, parent of the life insured. Okay, so preferred beneficiaries, spouse, child, grandchild, parent, life insured. So what happens there essentially is that if I leave money to any of these people, the creditors cannot go after the insurance policies. That's basically in a nutshell. If I leave anybody outside of the preferred, so my brother, my sister, my uncles, my cousins, and all that sort of stuff, they are not protected. Okay, they will not be protected. So these are the only ones that are protected. Okay, whether I name the revocable or irrevocable doesn't really matter. Okay, they are protected. Okay, so the question of revocable, of course, means that as the insured, I have all the rights. In other words, I can make any change I want to the contract. I do not have to get in touch with the revocable beneficiary to ask them for permission to change beneficiaries. I have all the marbles, you might say, stacked up on my side. Irrevocable beneficiary, of course, means that I have given that beneficiary now rights. Okay, and so therefore, if I want to change beneficiaries, I need to seek permission from that irrevocable beneficiary. If I want to cancel the policy, if I want to cash in the policy, if I want to collateralize the policy. So while under revocable situation, basically I as the insured have all the marbles, you might say, stacked on my side. Once I have somebody's irrevocable, I am now handed over my marbles over to that person. And now we basically are, both of us are mutually responsible for this. So neither one of us could do anything without the other person approving it and so on. Okay. In either case, what we always recommend, is that you always have a contingent beneficiary. Because once again, if there is no beneficiary, then the money will be paid to my estate. So, for example, if I was the life insured and my spouse was the beneficiary, and I died, and she died, and so therefore there was no beneficiary, where's the money going to get paid? It's going to get paid to the insured's estate, in other words, me. And then once again, subject to probate and taxation, creditors, and all that sort of stuff. And so to avoid all that, so in the absence of a beneficiary, like I said, it gets paid to the estate. So to avoid all that, we always recommend to have a contingent beneficiary. So I die, my wife dies, and then let's say the secondary beneficiaries could be our children. Let's say in equal proportion, something to that effect. So once again, the idea is to keep the monies outside of the estate, outside of the creditors, things of that nature there. So that way it's very, very clear what your intentions were in all of this, okay? So let's go on to talk more about product specifically too. So first of all, the individual life insurance. The basic things that we need to make sure that the insurance company is aware of is what they need to know basically in the application: name of the insured and the life insured, the amount of insurance, of course, that's payable upon death, and under which conditions it's payable. Is it an accident, natural death, that kind of stuff there. The amount and frequency of payment, what the grace period is. If you did choose a dividend, what kind of dividend did you choose? Conditions to apply for reinstatement of the policy, and anything that's applicable to how do you surrender the contract, any loans, paid up insurance, all these things here all form the individual life insurance contract. Okay, so there are, of course, statutory conditions in any of these contracts, and that statutory conditions, of course, is a copy of the application itself. Obviously, the contract that the insurance company issues, that forms part of the statutory condition. Any amendments that the insurance company might have given you to get signed on delivery, that's part of the statutory conditions. The delivery receipt, for example, that's part of the statutory conditions. So there's lots and lots of situations there that constitute statutory conditions. When it comes to reduction, generally speaking, it applies to reduced term insurance. So if the client did buy a product that's essentially mortgage insurance, you need to indicate how it reduces every single year, so the client is aware of of how much, what the exposure is year by year by year. So that's what we're talking about there. Now, there are, of course, sometimes exclusions. Some of these exclusions could be contractual. So, for example, we will not pay if you skydive. We will not pay if you scuba dive. We will not pay if you get killed while inebriated, or you're on drugs or whatever. So these are things that are sort of contractual. So they could be contractual in terms of health. It could be contractual according to your job, your occupation, contractual according to your avocations, which are hobbies, things of that nature. And then the other ones, of course, are imposed by law. So in other words, we will not pay if you get killed in the process of robbing a bank. In other words, you caused your own demise. So, for example, we won't pay on suicide costs in the first 2 years, let's say. That's an imposed by law, basically. So, therefore, it could be situations where if the contract stipulates that you committed an illicit act, the insurance company will not pay. So simple as that, because it goes from what they call against public order, basically. Okay, we also may not pay if there's any pre-existing conditions. Many companies will say, look, we'll cover everything except your back. We'll cover everything except your heart. In other words, heart condition, whatever. Okay. Suicide clause, we all know that first 2 years it will not pay on a normal policy. And of course, an AD&D policy, an accidental death policy, will never pay. It doesn't matter because suicide is not considered an accident. Okay. Some contracts would have living benefits, things that could be available. So, for example, critical illness is a living benefit that could be added to the individual life insurance policy. Okay, if it is a permanent insurance, it could have cash surrender value. So once again, the insurance company is obligated to tell you what that cash value is, how it's calculated, projections, all that sort of stuff. If there is going to be any kind of a loan or anything, you need to know the difference between a collateral loan and a policy loan. Okay, the simple definition is that if you borrow money from the insurance company, it could be subject to taxation. If you use your policy to go to the bank and you use the policy as collateral to borrow the money from the bank, then it will not be subject to any taxation at all. So in other words, the loan will not be subject to taxation, whereas a policy loan could be subject to taxation depending on the difference between your just the cost base and the amount of coverage, the amount of money you're taking out. Okay, in a collateral loan, it doesn't matter what the loan is. The money did not come from the policy; it came from the bank, and so therefore it will be not subject to taxation at all. And of course, many policies have riders where you customize your policy according to your needs and your budget and everything. So you should make yourself aware of the various different riders that are available, both on life insurance and of course on accident sickness policies. So we also have what's called group insurance, of course. So we have group life and health. So these are basically plans that are sponsored by your employer, and so they basically have benefits and features such as life insurance, such as accident sickness, drugs, dental, things of that nature. Okay, so as it says there, the plan has life insurance, AD&D, short-term or long-term disability, could have critical illness, certainly has health care and dental care. So there's a number of plans basically cover a full gamut of services under the plan. But remember, this is not individual coverage. This is a group coverage. And so therefore, it does need an employer, or in other words, a plan sponsor to make this thing happen. Okay. So the structure of a plan basically is that the plan sponsor, in other words, your company, gets what's called a master contract. And what you get is a certificate, basically, that proves that you are covered under under that particular plan. You also get a booklet that explains everything to you so that you have an idea what you're covered for, okay? How to access the copy of the policy if you want to read it. The employer may be generous and give you a copy of the actual policy itself, okay? And of course, all the terms and conditions as to how the plan could be terminated. Remember that group insurance is a one-year contract, so it's very rare that it ever gets terminated in midstream, but it certainly could be terminated on the anniversary date. So you need to know what the conditions are, terms and conditions that the insurance company could say, we don't want this anymore, the risk is too high, or whatever it is, and we decided to move on, whatever. So you could do that. Okay? So let's talk about annuities. There are two big blocks of annuities. The first one is what we call immediate annuity, and the next one is deferred annuity. In an immediate annuity, basically, you put in a whole pile of money. So your PV, your present value, basically, is the amount of money that you've actually deposited. So let's say you deposit $500,000 or something. And then, of course, the I is the interest. In other words, the green part is the interest. So immediate annuity, basically, is here's a bag of money. And I would like you to start my income within a year. That's why they call it immediate. So if the income starts within a year, that it is referred to as an immediate annuity. Okay. So as you can see by the arrows, basically, immediate annuity consists of the green, which is interest, and I guess whatever the color is there, reddish color, whatever, is your capital, basically. So the green part, of course, is interest, which of course will be taxable. And the reddish color there basically is your capital, so it will be non-taxable. Okay, so that's essentially an immediate annuity. And a deferred annuity is an annuity whereby here's my bag of money, but hang on to it because I don't need the money. I need it 5 years from now, 10 years. In other words, if the income is going to start beyond a year, it's referred to as a deferred annuity. Okay, so during the deferral period, basically, there is what we call the accumulation phase. So this phase here is the time where the money is basically sitting with the insurance company, growing in interest and everything else, okay? And during that time, okay, you can make withdrawals, surrender it if you want. It is expensive to do this, okay? So I caution you that these are long-term plans. So if you decide that after 2 or 3 years you want out, you may find yourself that you have a very, very high penalty, what they call market value adjustment. So we strongly recommend that when you make this kind of decision, you make it for the long haul, at the very least 5 years, if not 10, basically, So there is a lot of heavy penalties if you pull out the money during the accumulation period. Okay? Once the income starts, you cannot pull out your money. In other words, now we start making new payments, and so like the immediate annuity, we start paying you interest and, of course, your capital. So the interest will be taxable. Your capital, of course, will be tax-free and everything, okay? So basically, when we talk about annuities, we don't really talk about the insured. We talk really about a policyholder or a contract holder or whatever. We then also talk about the annuitant. And this is similar to the life insured, except that because there's no insurance here, we don't refer to this as the life insured. We refer to them as the annuitant. Okay, and the annuitant is the payee. In other words, the annuitant is the one that gets the monthly payments, basically. However, should that annuitant die, then of course the beneficiary receives the money if there is any money left, basically. But the annuitant, unlike a life insured where the life insured has to die before the beneficiary gets any money, the annuitant receives money while he or she is still alive. But should he or she die while the income starts and everything else, when the income starts, then a beneficiary will step in and receive the balance or whatever that how the annuity was all set up and everything. Okay. Segregated funds, as you know, segregated funds are the insurance company's mutual funds, okay, and they are governed by the insurance legislation, okay. So the segregated funds are not governed by the Securities Commission. Mutual funds are governed by Securities Commission. That's why in a mutual fund you always give a prospectus, basically. In segregated funds, because they're governed by the insurance legislation, you don't give out a prospectus. You give out an information folder and a fund facts, basically. In other words, information folder is sort of a summary of how the segregated fund works, what the MER is, or how you withdraw your money, when the maturity date is, what the guarantees are, all those kind of things there that you learn when we talked about segregated funds. But also, you must also give them what's called fund facts. So fund facts is specific to that particular fund. So if you buy, Canadian equity fund, then you get a fund facts on Canadian equity fund, basically. So you get an information folder that gives you information, sort of a broad look at the segregated fund legislation, rules, regulations, guarantees, all that. And then depending on the fund that you actually purchased, you will then get another document which we call a fund fact. And that is specific to that particular fund that you bought, okay? So in an IVEC, basically, the insurance company owns the funds. So you don't own the funds. You have what's called a notional account. So they own the fund, and so therefore they manage it for you. They do all that sort of stuff there, okay? And basically, the investor, you, in other words, are basically tied in to the insurance company through what's called notional accounts and everything. But for all intents and purposes, your name is on there. It's your money, and they're managing it on your behalf, okay? So at some point, the insurance company has to pay out a claim. Okay, after all, that's the business that we're in, is pay out claims and everything else. Okay, so the claims are basically, in order for a claim to actually be satisfied, in other words, one of the requirements is that, first of all, we now have to provide satisfactory evidence that the life insured has in fact died. Obviously, we need to be told, first of all, that this person has died. In other words, as I say, notice of claim, basically, somebody has to tell us. So usually the beneficiary or the life insurance agent, the guardian or the power of attorney, somebody, in other words, gives us a notice of claim. And so then we need proof, obviously, that the person died. And then, of course, that comes from the funeral home, basically. They usually have these kind of things, okay? And so then you have a second thing that has to happen is we have to have proof that the claimant, in other words, the beneficiary, is entitled to death benefits. In other words, not just anybody can show up and say, here I am, give me my check. You have to be the right person to get the money, so you have to provide proof. So let's take a look first at the process itself. So as I said, the first thing we have to look at is the notice of claim. Somebody has to tell us that that person has in fact died. Once we do that, then we send out to whoever gave us that information what we call the documents, okay, the proof of claim documents. So there's a claim form, basically, that has to be filled out, and that'll be filled out in conjunction with the beneficiary and everything else, okay? Identity of the deceased, we need to know who was it. In other words, a policy number, this, that, or the other. Proof of death, of course, the coroner's report or the funeral home report, whatever. We need to ascertain the insured's age. to make sure that the age that we have on file is the actual age. And remember that if there is a difference, then the insurance company will modify the actual coverage according, okay? We also have to have proof that the claimant has the right to receive that money. In other words, are you the rightful claimant or are you somebody else, okay? Whatever. So we need to have that proof. And of course, we need to know who the claimant's age, the name, and of course identity. So once again, if that child, if that claimant is a 14-year-old, well then obviously we can't give them the check. So we're going to have to pay it to either into court or their guardian or somebody else. But we certainly can't give it to the child. That's for sure. And that's why we always ask for the name, age, identity, things of that nature there. From time to time, there's a possibility that an insurance policy may be stuck in probate. If you remember, I said that in the lack of an owner or a beneficiary, the money will be paid in the estate. And so that means now that the monies are sort of frozen in the estate, and we have to wait until the will is probated and all that before monies can be released. Okay. And the last thing, of course, we have to ascertain: was it an accident or was it natural cause? And we need proof that in actual fact it was an accident, because sometimes people are inebriated. In other words, a DUI, for example. Well, then you're not going to get paid under the accident provision. You'll get paid under natural causes, but you're not going to get paid under the accident provision. So we need to ascertain basically whether the individual was under the influence or whatever it is. So that way we need to establish whether it really was an accident or whether it was a natural cause and everything else. Okay. Now, of course, the claimant themselves could be the insured. In other words, I own a policy on my spouse, for example, and I am the beneficiary. So I'm the insured and I'm the beneficiary. I could do that. Of course, it could be the insured's estate, which we obviously do not recommend because, as I said, it could be stuck in probate. It could be creditors could go after taxation, all that sort of stuff. Designated beneficiary, whether primary or a contingent beneficiary. It could be the assignee of the policy on death. In other words, a collateral assignment. If I assign the policy before I die, I assign my policy to the bank, and I still owe money to the bank will get the first dibs. Of course, they are what they call secure creditors, and then the money will get paid. The balance of the money will be paid to the beneficiary. So that's what I'm saying. The bottom of the creditors, if it is in fact going to be, if it has been collateralized, then obviously the creditors get paid first, and then the balance will get paid to the beneficiaries. Okay. Now, sometimes there are some special circumstances under which the monies may have to be basically held on to, and one of the big ones, of course, is presumption of death. So in this case, if the insured person remains missing for 7 years or more, a request can be made to the court to declare the person dead. In other words, at the 7th year, if that person does not show up because we have, the body simply has disappeared, we've never seen the person again, then whoever is the beneficiary of the policy, the estate, whatever, could certainly apply to the court to declare this person legally dead. But it is a 7-year space of time. Now, again, if it can be proven that under the circumstances, the likelihood is that this individual did die before the 7 years, even though we haven't seen the body. So, for example, if the ship went down, or the plane went down, or there was an earthquake, or there was a hurricane, and this person simply has disappeared from the face of the earth, it's quite likely that this person succumbed to their injury because of those particular circumstances. So, once again, you could apply before the 7 years up, because it's all perfectly obvious that this individual, the ship went down, we recovered some bodies, but we never recovered his or hers, whatever. Likely is that yes, he or she is dead, and so therefore, we should pay out, or whatever. Okay, but otherwise, if we can't do that, then you do have to wait the 7 years, and at the end of that, that person will be considered legally dead. Now, if a policy has lapsed due to non-payment of the premium, proof may be required that death occurred when the policy was in force. So if, for example, fifth year rolls along and you can't afford to pay the premium and all that, so the policy now lapses. However, if you can prove that that ship went down 2 years before, and there's a strong possibility that that individual might have succumbed to their injury during that time, and during that time, of course, the policy was in force, then, of course, you can put in your claim. because the person was covered at the time of death and everything else. Moral of the story is we always recommend that you keep it. Pay the premium as best you can up to age, for the 7 years, just to be on the safe side. Now, sometimes what happens is two or more people could in fact be dead at the same time. So in other words, sequence of death is important in determining who's entitled to insurance proceeds. If it is not possible to determine who died first, the policy may state who's presumed to have died first. So most of the times, most companies will assume that the beneficiary died first. That's the usual rule, is that if we cannot establish who died first, then it is presumed that the beneficiary actually has died first, and therefore the money then will be paid to the insurer's estate. Okay, if all of this doesn't work and there's still a dispute and everything else, the last resort, basically, the insurance company will have is to pay the money in court. And this is where, of course, could be conflicting claims. So, for example, it could be a current wife and an ex-wife, let's say, fighting over the proceeds and everything else. So, insurance companies don't like to get involved in that kind of stuff, and so therefore they need to pay it out. They pay it into court, and then the warring factions can fight it out in court, basically, okay? And because what they want, obviously, is they don't want to incur any further liability. And so therefore, as long as it can be determined that that money must be paid out because the person did in fact die, so quite legitimate and everything else, then they're just paying the court because they don't want to incur any further liability. They don't want to be involved in this thing anymore. And of course, if it's a minor situation, so 14-year-old son or something, whatever, then obviously the money cannot be paid to that minor, and so once again the money will have to be paid into court to protect the interest of the child until they're age 18 or age of majority, and the monies then will be released at that point. Okay. In terms of accident sickness claims, of course, the whole idea of an accident sickness force is that you had an accident. So the actual dismemberment claim is paid to the policyholder. Because remember, that person is still alive, obviously, so this dismemberment portion. The death portion, of course, will be paid to the estate or to the beneficiary. So in other words, in A, D, and D situation, the actual death portion is paid to the beneficiary or to the estate, but the dismemberment portion will be paid to the policyholder because obviously they're still alive. Okay. Disability claims are obviously paid to the insured because that insured is still alive. So that's obvious. Okay. So in order for a disability claim to actually happen, in other words, just like we had issues with life insurance, we have also issues with disability. So the first thing we need is that there is an APS. In other words, the attending physician statement is crucial here because we need proof from the doctor, not from a nurse, not from a paramedic or whatever, but an actual MD that you are in fact disabled. That's crucial. Okay. You also, of course, have to satisfy the waiting period. So 90-day waiting period, you're not covered the first 90 days, okay? There must be evidence that the insured is unable to perform the particular duties that he is insured for, okay? We may require medical exams. In other words, we may like to have our own doctor do an assessment of the risk and everything else, okay? And he may also see specialists. In other words, rehab. While we cannot force a person to do rehab, we can certainly make a strong case for it. Basically, okay. So they will pay for rehab. In terms of critical illness claims, the medical proof obviously is to make sure that he's covered for the particular illnesses that, in other words, he has the illness that he's covered for. And as you remember, the big four: heart attack, strokes, cancer, and bypass surgery. But remember, there's all sorts of other things as well. So we need to establish, is he claiming against, claims, medical issues that are covered. Okay. So we need proof of that, again, from your doctor, from an MD and everything else. And once again, you have to satisfy the survival period, which is, in most cases, it's 30 days from the date of diagnosis. Okay. Remember, it's 30 days from the date of diagnosis that you must survive your illness. Okay. When a person dies and has a segregated fund or annuity, again, here it's a little bit different than most people are aware. Okay. So if death is before the retirement, so this is retirement seg funds or annuities, the spouse is entitled to benefit, even if the beneficiary is someone else. If there is no spouse, the named beneficiary will receive the benefit or be paid to the estate of the deceased. In other words, even if I have my son, let's say, is the beneficiary of my seg fund or my annuity, but I also have a spouse and I die, my spouse takes precedent over the beneficiary. If there is no beneficiary, then of course it will go to the beneficiary or the estate or whatever the case may be. So if I die prior to retirement and I do have a spouse, the spouse takes precedent over the beneficiary. If then the spouse dies, my spouse dies, and there's still money left in the pot, basically, then my beneficiary could receive a lump sum or whatever, depending on the type of contract. But you can see here that the spouse always takes precedent over the beneficiary. What happens if I die after retirement? In other words, I've already started getting an income and everything else, okay? Once again, if there's a spouse, the spouse is entitled to a benefit. It is a reduced benefit, usually 60%. Okay, of whatever I was entitled. So if I was getting $1,000 a month, my wife would get $600 a month, basically. If there is no spouse, then once again, the named beneficiary would receive the commuted lump sum. In other words, they don't want to necessarily pay for forever and a day, obviously. So they'll simply do what's called a present value, and they'll just hand over a check to the beneficiary. If there is no spouse and no named beneficiary, then the commuted lump sum, of course, will be paid to my estate. Okay, and then whoever's the recipient of my estate will receive the funds and everything else. Okay, the next couple of slides are really all about you, and I'm not going to spend any time reading the pink part because it's just a screen catch of what's already in the book and everything else. So it's already word for word basically in the book, so you can read that on your own. But what I do want to make sure that you look at is the bluish side of it. So basically, the idea of governing of life agents is for you to demonstrate ethical conduct. Giving constructive advice to your clients, basically, so you can build a trusting relationship, basically, between you and your client. Okay, and so this we're saying is manage conflicts of interest. In other words, don't put yourself in a position where you could find yourself in conflict of interest with your client. Okay, do a needs analysis for your client. How can you make any kind of recommendations if you don't understand, if you don't know what the client's needs are? So do a needs analysis. Sell the product ethically. Don't tell them that the product does something that it does not do. Make sure that you very clearly indicate exactly what it does and nothing more. Remember that you have a fiduciary duty. In other words, fiduciary means trust. You have a trust position with your client. They trusted you. When they hand over the check to you, they're basically saying, I trust what you said, and so here's my check, basically. Do not violate that fiduciary trust, okay? That's very, very important, okay? And of course, you have to satisfy all statutes, regulations, codes of conduct, and everything else, okay? In other words, statutes, laws, laws by the land, by the regulators, and of course, if you belong to the associations or their codes of, code of conduct, okay? So basically, if you're violating any of these things here, you can receive a fine, you can lose your license or both, basically. So these are very, very serious things, so they cannot be taken lightly. So there's various different regulatory authorities that you are going to be reporting to. For the most part, you will be reporting to your province or territorial authorities. So, for example, Ontario is FSCO, Alberta is British Columbia Insurance Council, that kind of stuff there. So basically, these are the regulatory. So we have 10 provincial regulators, and of course three territorial regulators. CICERO is the governing body for the material, the study material. So this is a interjurisdictional organization that creates a standard for studying. So the book that you're studying from to get your life license is called the CICERO book, because this was owned and designed by CICERO. So it doesn't matter where you take your course, whether you're taking in BC or whether you're taking in Newfoundland, the book is the same. Okay, and so therefore, CICERO's responsibility is to create a standard across the land that everybody taking the life license have the same material, they learn from the same book and everything else. So that way it creates a standard. So other authorities, of course, which we've talked on a little bit, the Office of Privacy Commissioner of Canada, that is, of course, PIPEDA, if you remember. Then we talked about financial transaction reporting analysis, which of course is FinTrack. And there, you remember that you need to ascertain the client's identity. In other words, if you suspect anything at all, you need to get a copy of their. It has to be an original. You have to see an original. The driver's license, certificate, birth certificate rather, landed immigrant status, passport, things of that nature. There, maybe a legal document, basically. You must report that suspicious transaction within that 30 days. Okay, that's law. If you knew what you knew and you didn't bother, you could be liable yourself. Okay. You also have to ascertain whether this person is a politically exposed foreign person. In other words, if somebody walks in and has $100,000 or more, and they buy a non-exempt product. Remember, these are all regarding non-exempt, not exempt products. Then you need to know. So the question you have to ask is that: have you ever worked for a government? Are you a judge? Or you a general? Are you whatever member of parliament? Any of that kind of stuff there, because unfortunately corruption happens, and usually it happens from the top, not from the bottom, basically. Third-party determination, that is, if somebody walks into your office and they give you a check, but the check is not payable to the person that's in front of you, it's made payable to somebody else, but that somebody else endorsed it. And then said, go ahead and cash it, you might say. You better be very, very careful before you accept that check. So you need to find out, who is this person? Why is he giving you this check? Where do they live? And so on and so forth. Again, very well explained in chapter 4 of the ethics book. Assures, all of you by now should know that Assures is essentially a basic consumer protection agency. So in the event that an insurance company should fail, how is the consumer protected? And of course, they're protected for 85% of whatever they're entitled to, no less than a certain number. So, for example, life insurance, $200,000. Anything that gives you a monthly income is $2,000. Health insurance is $60,000. So, once again, very well explained in Chapter 4. So you should go back to those. The other one is Umpad service for life and health. That is, if the insurance company in question denied your claim and you've exhausted all possibilities with that, in other words, you're not getting anywhere, then you can phone Umpad service and state your claim there, and they will act on your behalf. This is a free service, so you don't have to worry about payment or anything on the line. This is provided for it's all financed by the insurance company, the health insurance industry, basically. So for you as a consumer, it's a free service. So all you have to do is basically register a complaint with Umpad service, and then they will fight it out basically with the insurance company and try to come up with some kind of a settlement of some sort, okay, if any, okay. And then the last one, the Canadian Council of Insurance Regulators, that is regulates the insurance companies themselves. So like CISRO, it's a inter-provincial jurisdiction basically that tries to again create some kind of harmony between all the various different insurance companies, wherever they may be across Canada. So that way we have some consistency in rules and regulations and conduct, all those kind of things there. So we can create a healthy and competitive environment, which of course will be very helpful for all of the consumers and everything. Okay, so you can also belong to a number of professional associations. These are things that you may or may not be aware of. Okay, the first one is the Canadian Life and Health Insurance Association. You as an individual cannot be a member of CLHIA. This is membership only for the insurance companies themselves. So this is basically a lobbying group, a research group, information gatherer, okay. But it is for insurance companies only. Almost every insurance company in Canada belongs to the CLHIA. So you as an individual cannot, but insurance companies can become members. Advocates, of course, you as an individual can become a member of that. The Independent Financial Brokers of Canada, IFBC. Again, as an independent, you can join IFB. Strongly recommend either Advocates, IFB, or both, whatever. CALBA, if you're an MGA, you should belong to the Canadian Association of Independent Brokers. This is, again, lobby, research group, and all that for the MGA world. And if you're a CFP, then you should be a member of a Financial Planner Standards Council. And this was a regulator basically for the CFP, Destination Certified Financial Planning Designation. So these are all organizations that all have rules and regulations, code of ethics, things of that nature there. Again, to create some kind of a standard that and the consumer will have faith in our industry in knowing that it is well-regulated industry. So getting back to you, basically, what are the core ethical values? In other words, what are the absolute things that you must, you must follow through on? Okay, so the agent must ensure their business practices follow ethical standards, such as acting in good faith. There's always a question on the exam in terms of what is the definition of acting in good faith? And that is a duty of care. In other words, you have a duty of care to do the best you can for your client. This is not about you. This is about your client. Okay, and so therefore, don't get yourself into a conflict. Make sure that you're acting in the best interest of your client first and foremost. Okay, competence, which of course is basically what you do now, studying. In other words, you have a responsibility to keep up with what's going on in your industry. The consumer has the right to know that you know. Okay, and so therefore it's very important that you keep up with your studies and everything else. So getting your license is just the beginning, it's not the end. It's the beginning of basically a lifelong learning system. Integrity, of course, is perfectly obvious. Be honest, okay? Be trustworthy, be dependable, all those kind of things there, okay? As I said earlier, you must manage conflict of interest properly. So if, for example, your company has a contest, it's a free trip to Paris or something for you and your spouse, you need to let your client know that, Mr. Jones, I'm giving you this product, but I should let you know that the insurance company in question obviously has a contest, and so I just wanted to let you know, so make sure there's no conflict. Are you okay with this? In other words, you really need to make sure that the client is aware that there could be conflict here, there could be a potential conflict of interest, because you don't want this thing to bite you later on when something goes wrong. Refrain from unfair or deceptive practices. We'll look at those a bit more because there's quite a few of them, okay? Make proper disclosure. In other words, who are you? What companies do you represent? Disclose the product. Don't embellish on the product to the point where it's unbelievable, so to speak. In other words, tell the client exactly what the product does and what it won't do. Just again, keep it honest, essentially. Act in compliance, regulation, and codes of conduct. In other words, your association code of conduct, act in obviously in the best interest of the industry, your client, and so on. Okay, and handle complaints in a timely manner. If a client registers a complaint or sends you a letter or whatever, act on it immediately. Don't slough it off, because all you're really doing is pushing the inevitable down the road, and eventually you're going to find in front of a tribunal somewhere defending your position. So if you have a situation, deal with it as best you possibly can, and remember, you do have errors and omission insurance that you have to buy, so it protects you against errors and, of course, omission. In other words, liability insurance. Okay, so let's take a look at some of those deceptive practices that are essentially saying, do not do this, or if you do it the right way, so protect yourself. The first one, of course, premium rebating. That's a deceitful practice. If you tell your client, look, buy this product and I will pay half a year's premium or something to that effect, then I'm sorry, that simply will not work. Insurance is not free. And so therefore, you cannot rebate any portion of your premium. Twisting and churning is basically, twisting is when you replace a policy with a different insurance company. Churning is when you replace a policy with the same insurance company. And again, sometimes it is necessary to do that. But what they have right now may not necessarily suit their needs. So there's nothing wrong, nothing illegal about twisting and churning. However, what is the problem is that you must do it right. In other words, you have to complete allure. Remember the life insurance replacement declaration document. So fill out allure, basically, and say, okay, here's what you now have. Here is what I am proposing. Here are some things you should be aware of. In other words, here's the suicide clause. Here's the contestability clause. In other words, make the client aware that when you cancel no policy, there are some ramifications. There could be taxation issues. There could be cash value in the policy. In other words, full disclosure. And so the allure is very, very important in all this. It protects you, protects the company, and it protects the consumers as well. Traffic in insurance, that's basically when you are buying an existing insurance policy from a client. which you're handing them a check, basically. So the client's got a $50,000 policy. They're in dire straits, or they need money, or whatever the case may be. So I say, I'll buy the policy from you for $10,000, let's say. And then, of course, you now own the policy, and of course, you change the beneficiary to yourself. That is trafficking. In Canada, for the most part, it is frowned on, and in some provinces, totally illegal. Okay, to actually do that. So trafficking is actually what they're called biaticals. Sometimes they call them life settlements. For the most part, first of all, they're very badly, they're frowned by insurance companies in the first place. But in some provinces, it actually is illegal to actually do it. Okay. Fronting is when somebody submits an application through your contract because they don't necessarily have a license themselves. So basically, they wrote the business, but because they don't have a license, they have nowhere to place it. So they put it through your contract. And of course, now you're fronting for them. So you're using your license to accommodate them. And so therefore, the issue really is that it's illegal. You must see the client. You have to be there with, and you sign it and so on. But if somebody comes along and just gives you an application and says, I don't have a contract, but I filled this out for you. He's a good guy, good client, blah, 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 and all that sort of stuff there. Sorry, it just doesn't work. You have to go see the client. Otherwise, you're going to find yourself in front of a tribunal again, basically. Okay. Misrepresentation, that's perfectly obvious, okay? If you misrepresented the product, misrepresent the company, all those kind of things there, then you're liable because again, you're not telling the client the truth or anything. Forgery, as you know, that's a criminal offense. Signing the back of a check, you might say, or signing the bottom of an application because you missed the signature or something. That is clearly against the law. That is actual criminal offense. You could end up in jail for forgery. So you cannot do that. Okay. Commission sharing. You cannot share commission between a licensed and non-licensed person. In other words, if I have a license and you don't, so I say, give me I'll take care of it. I'll see the client, I'll take care of it. And then when I get paid, I'll split the commission with you. That is clearly against the law. So splitting of commissions between licensed and unlicensed person is clearly against the law. Nothing wrong with commission sharing between two or more licensed people. That's fine. The insurance company more than happy to do that kind of stuff there. But between an unlicensed person and a licensed person, clearly against the act, basically. Defamation, that is defamation of character of the individual or defamation of the company. Okay, so if you slandered or you defamed the good name of the insurance company or your colleague of yours, and in the process of doing that, they've lost reputation or they've lost business or they've lost money or whatever the case may be, and it may clearly shown that you defamed their name, basically, then they could sue. And you could find yourself again in front of a tribunal trying to defend yourself. So these are things that you've got to be very, very careful about before you commit any serious crime, because nobody likes to be deceived, basically. Okay. So other product services that you could get, you get a separate license is required to sell products and services for P&C. In other words, your life license does not allow you to sell car and homeowners insurance, so no property and casualty insurance. You can get a license for that, of course, but life insurance license will not allow you to do that. Again, you can get a securities license if you want, so you can trade in stocks, bonds, things of that nature. There, you can also be a mortgage broker and also get a license. So so that license that you have right now does not allow you to do any of those things, but it doesn't stop you from getting those licenses. In other words, no restriction here at all. Okay, so other products and services where you don't need a license at all, that is to act as a deposit broker. In other words, if you're opening up bank accounts for your clients and all that, and the bank gives you 25 basis points for your troubles or something, whatever, you don't need a license to sell a deposit account for the bank, okay? And you don't need a license to be a financial planner, okay? You will probably need a designation like a CFP or something, or a PFP or a CLU or something like that, but you don't get a sort of financial planner license, because financial planner is a designation. It's not actually a license, okay? But again, you should work towards, as your career grows and everything, can be a good idea for you to work towards your CFP, CLU, things of that nature there, okay? So I think that we are finished for today. So again, if you have any questions resulting from this particular boot camp, of course, check your email address on your contact page of your website. There, you'll see it. And emails, we'd be happy to answer any of those questions. Usually, I try to get back to everybody within 24 to 48 hours. I have been getting quite a few in the last little while, so I really appreciate it. So by all means, continue on. And if there are no questions, I will bid you a good evening, and we will talk to you soon.